This is SJC-11582, Commonwealth v. Dwayne Moore.
Attorney Wood, good morning.
Good morning. May it please the court. Chauncey Wood for appellant Dwayne Moore. The Commonwealth's theory in this robbery murder case was that Dwayne Moore laid in wait with Kamani, Washington, outside 23 Sutton Street. Kamani, the Commonwealth's star witness, who was testifying pursuant to a plea agreement, asserted that he watched Moore call drug dealer Simba Martin in order to lure him outside so that they could rob him. Kamani testified that after Moore called Simba, Simba came out and Moore participated in the robbery, holding a gun, and eventually shot all of the victims. None of that was true. The cell phone records the Commonwealth presented to the jury supported its version of events, a version that made sense. Indeed, the Commonwealth argued in closing that those records provided ironclad corroboration for Kamani's testimony. But if the jury had been given Simba Martin's cell phone records, the Commonwealth's version of events suddenly would not have made any sense. In the words of the prosecutor in closing, phone records don't lie. The Commonwealth would have been forced to resort to accidental butt dials to try to make sense of these records. The parties failed to present indisputable evidence that Simba's customer, Marcus Hurd, called him at 12:40 a.m. as Hurd was turning onto Sutton Street, and that Simba was already outside his apartment at 23 Sutton Street at 12:40, waiting for Hurd at that time. Both Hurd and Kamani, Washington testified that as Hurd parked his car, Simba approached Hurd's silver Ford Edge, they chatted briefly, and Simba got in the passenger side. Hurd testified that 2 to 3 minutes later, Kamani approached the car and began the robbery at approximately 12:42 a.m. Because Moore's last call to Simba was at 12:52 a.m., Simba's cell phone records provide powerful evidence that Moore was not present when Simba left his apartment at 12:40 a.m. When Simba began the robbery, strike that, when Kamani began the robbery, or when Moore placed his call at 12:52 a.m. Had the jury known Simba was outside his apartment at 12:40 a.m., it obviously would have affected their conclusion, given that this flatly contradicted the Commonwealth's theory of the case. The Commonwealth never disputes that Simba was already outside his apartment at 12:40 a.m. when his customer Hurd called him as he was turning onto Sutton Street. And yet the Commonwealth does dispute that Moore placed his 12:52 call after the robbery began. The Commonwealth seems to...
Attorney Wood, I don't mean to interrupt you, but all of these cell phone records, is it your argument that they support the inference that Mr. Moore was not there?
Yes, absolutely.
Okay. From that premise, though, that's not the only evidence upon which the Commonwealth rested its argument. There was eyewitness testimony. There were statements made by Mr. Moore himself that were contradictory, that he never left his apartment, but then his cell phone records put him in the vicinity. So it's not the identification of the shooter wasn't just based on this. There was other evidence that corroborated that fact. And the other one was, maybe just inferentially, Mr. Hurd testified that Kamani made statements to the effect that I'm leaving. If you want to know who did it or you want retribution, I'm from the point, come to the point. So there is no testimony, there's no dispute that Mr. Hurd said that the other perpetrator had gone. So if you add all of the other stuff with the eyewitness description of someone who matched Mr. Moore's physical appearance, his contradictory statements that he was not in the vicinity, but his cell phone records, isn't there other evidence upon which the jury could have found other than just these cell phone records? So dispositive could they have been to the jury's determination of identity?
Well, Your Honor, that is, I detect at least three big questions there, and I want to address all of them. The answer to your bottom line question is, I'm attempting to demonstrate, and I believe firmly, the answer is the cell phone records were absolutely central and material. But that's where I'm going with this very long answer to three questions. First of all, the witnesses. You say, didn't the Commonwealth cite three other eyewitnesses? The answer is yes. In their closing argument, they did cite three other eyewitnesses, specifically Dedrick Cole, Marcus Hurd, and James Jones. Now, I've already briefed my view about Dedrick Cole and Marcus Hurd. Very shortly, very briefly, Dedrick Cole was not an eyewitness. All he said was, Dwayne Moore called me up and asked to borrow a car for a robbery. He wasn't present. He can't place Moore at the scene. But beyond that, more importantly, very bluntly, the police looked at Dedrick Cole's cell phone records. There is no corroboration. Dwayne Moore never called him, not with his main cell phone, which he used to call Kamani Washington and Simba Martin, and not with his track phone, which the police found in his apartment. Bluntly, Dedrick Cole is lying. Second, Marcus Hurd. The Commonwealth, for reasons I don't understand, and closing, cited Marcus Hurd as corroboration. But as we outlined in our briefing very carefully, Marcus Hurd was merely corroborating that Kamani Washington was there. The best he can say about the other guys is one of them was a tall, skinny guy. Well, that's not helpful. That's all he can say. The third person, James Jones, because of the briefing constraints, we submitted a very long brief with the court's permission. I could not adequately brief James Jones. So I'm going to have to rely on the court to dig into this. This is crucial. James Jones is one of the eyewitnesses who claims to see somebody exactly fitting Dwayne Moore's body type across the street shooting what we now know is Simba Martin twice in the head with a .40 caliber Iberia. Here's the two crucial points you need to know. One, Fitzgerald Allen. Please remember this. Fitzgerald Allen testifies to the exact same thing, but he describes this shooter as a stocky male. He's describing Kamani Washington. And more importantly, how do we know that Fitzgerald Allen's right and James Jones is wrong? Follow the .40 caliber Iberia handgun. There's no dispute. Kamani admits it's his gun. The ballistics demonstrate that whoever was shooting Simba Martin in the head while he's lying in the intersection is holding the .40 caliber Iberia. Where does the .40 caliber Iberia go? Kamani Washington says he takes his black bag with his two handguns, one of which is the Iberia, straight to his brother's house, hides it under his brother's bed. The police find that bag with the two handguns, including the Iberia, the next day. And Kamani admits, those are my guns. That demonstrates that Fitzgerald Allen is right. Kamani Washington was the guy who gave the two headshots to Simba Martin with the .40, and not Dwayne Moore. So that's that corroboration, those witnesses. Second, your second question, what about Dwayne Moore's statement? He placed himself at the scene, for goodness sake. He's obviously lying. With all due respect, Dwayne Moore's statement that he made to the police, he says, I'm trying to buy drugs from Simba Martin. But in any event, what he says is he comes to the scene after the robbery has started. He says he hears voices upstairs and he leaves. That's what he says. It's also in response to a false allegation by Detective Brown that they could place him at the scene. They couldn't actually. But the main point is he's saying, I come upon the scene after the fact. That is not proof that he's there for the beginning of the robbery. Finally.
But isn't that his second statement though? Because didn't he make an statement that he wasn't even there, that he never left his apartment or something to that effect? And he said, check the records, check the records.
Yes. So you're right that he gave two statements, and you're right that in the first statement, he denies. And you're right that in the third statement, well, denies in the sense, I never left my apartment. And you're right that in the, sorry, not the third statement. In the second statement, he says, okay, I did leave my apartment. I went, and his apartment is at 725 Morton Street, right around the corner. He says, at the time, he says, I walked over to 23 Sutton Street. I heard voices upstairs and I left. That's what he says. So you're right that he gives two different versions, but he does not place himself at the scene at the beginning of the robbery. Now, finally, the get back speech. You make reference to Kamani Washington's speech, the get back speech. The get back speech is in fact exculpatory. That's very important evidence. I think your significance, I think you're attaching to it, and correct me if I'm wrong, a misunderstanding, is that he makes clear that he leaves. And so therefore, I'm not quite sure. The other two robbers, Kamani's not the gunman. I'm not quite sure how that implicates Dwayne Moore, but it is crucial evidence. Go ahead. I'm sorry. Go ahead.
It implicates it in the sense of there's other evidence that would put Moore on the scene as being the shooter. So I understand that, but the concern that I have is a lot of what you've described for us seems to be credibility assessments and judgments that the jury is the final arbiter of. And I understand that you say that it should be looked at a way that's more favorable to Mr. Moore, but the jury's not obligated to look at it the way that you're looking at it.
All right. So I'm going to answer the impeachment question that you raised, and then finish, I think, coming back to the importance of the get back speech. So how is this not mere impeachment of Kamani Washington? And you could state it further. Look, this jury clearly didn't believe everything Kamani Washington said. So isn't this just more impeachment? And haven't we said all over the place, mere impeachment can't possibly reverse a conviction, never mind a quadruple murder conviction, for heaven's sake. Here's the crucial point to that very good question. Kamani Washington was the sole pillar of the Commonwealth's case. I've already gone through the other evidence. He's the sole pillar, corroborated only by, in my view, reliably, cell phone records, but an incomplete version of cell phone records. So what we really are talking about is the significance of the impeachment of the sole pillar with impeachment of the sole corroboration, cell phone records. And I cite in my brief at page 78, the dispositive case here, Commonwealth v. Cowles, where new evidence impeaches or undermines a key witness whose credibility at trial was suspect, that's Kamani Washington, whose credibility was suspect, it increases the importance the jury would have assigned to that additional impeaching evidence. So here's the point. The point is that in this sole pillar case, where Kamani Washington is the centerpiece, evidence that would further impeach him.
So I understand that.
Thank you.
Sorry.
Sorry.
I guess my question to you is a little more basic. What is the new evidence exactly? I understand the jury had some phone records. What phone records did they not have?
Yes, this is
that you
incredible.
did not have access to, or that your client did not have access to?
Thank you. Okay, so thank you for that question. It's a very complicated fact record. The answer to your question is that the jury was not introduced into evidence, Simba Martin's cell phone records. So Marcus Hurd's cell phone records were never produced. Nobody got them. And by the time I got involved, we couldn't get them. So Marcus Hurd's cell phone records were never produced. What we're talking about is Simba Martin's cell phone records. Now, the defense did have those records.
Yeah. So,
Yeah.
so the defense did have those. Okay.
Yes, and the prosecution had them as well. So this is why we framed that it's doctrinally complicated, because both sides could have introduced them and neither side did. So we've raised this both as a due process violation, prosecutor's failure to introduce relevant evidence, and ineffective assistance for defense counsel's failure to introduce the records. In the evidentiary hearing on the new trial motion, we make clear that defense counsel did not appreciate this exculpatory aspect that Simba Martin's cell phone records established. And this is the second answer to your question. Why are those so important? What do they add that the other records that were introduced did not add? That's what I think you're asking as well. They established, and only Simba's records established, that he was outside at 12:40 a.m. That's what is, because Marcus Hurd is calling him. We know that from Simba's records that Marcus's call comes in at 12:40 a.m. as he's turning onto Sutton Street, as he's saying, "Hey, I'm here to pick up my weed." Sutton Street is only 1 block long. He says very clearly in his testimony, he heard, "I was calling him as I was turning onto Sutton Street. His house is 1 house away from the corner, and I saw him outside as I hung up." That places Simba outside at 12:40 a.m. So that's the crucial exculpatory point. Now, I want to finish my answer to Justice George's, because I think this takes me to the second point. The get back speech. What's the importance of that? That takes us to the second issue, the suppression of exculpatory evidence. This is a Brady claim. During the crime, Kamani gave this get back speech in which he said, "I'm from the Point," a synonym for the Columbia Point Dogs, the largest street gang in Boston at the time, with a reputation for committing precisely this sort of crime. 1, violent robberies of local drug dealers. 2, while repping the Point, that is, announcing they were committing the crime on behalf of Columbia Point Dogs. And it is clear, this is what transforms this into Brady. It's clear that the Boston police investigating this crime were aware, first, the existence of the Columbia Point Dogs. 2, that they were known as the Point, as Kamani kept saying, "I'm from the Point." 3, that they robbed local drug dealers. Simba Martin was a drug dealer. And 4, that they repped the Point during robberies. The police, might seem to us a strangely specific thing. The police understood at the time that what repping the Point meant. They understood Kamani Washington's speech in the middle of this horrific crime to be something very specific. "I'm from the Point," not the geographic location Columbia Point, but from the Columbia Point Dogs. Therefore, they investigated, they admit this. This is not subject to dispute. The police admit they investigated the possibility that this get back speech meant that Kamani was repping the Point and therefore was from the Columbia Point Dogs. Detective McLaughlin frankly admitted that he investigated this. On top of that, Dwayne Flannery, the brother of victim Ayanna Flannery, the uncle of victim Amani Smith, called his brother from the jail and said, "Let's get retribution against the Point," or the Columbia Point Dogs. So the police knew that as well. They understood from multiple points, self-affiliation by Kamani, the substance of Kamani's get back speech, and Dwayne Flannery, and they believed this is possible, that this was a crime on behalf of the Columbia Point Dogs. Finally, why is that exculpatory of Dwayne Moore? Why can't Columbia Point Dog Kamani be doing this and doing it with Dwayne Moore? The answer is that if Kamani is doing this on behalf of the Columbia Point Dogs, he suddenly has a very specific incentive to blame someone who is not his fellow gang member. This is a point recognized by this court over and over again, that where you have gang affiliation.
Connection between the newly discovered evidence of a connection between Kamani and the Columbia Point Dogs. Where is that in the record? Is it just the statement? Is it the subsequent investigation by the feds? I thought that they looked over 18 months and found nothing connecting Kamani to the Columbia Point Dogs.
So the answer to your question is, I'll go back. There is evidence. There's indisputably evidence. The evidence is Kamani's self-affiliation. This court in Commonwealth v. Lopes explicitly recognizes self-affiliation. "I'm from X gang" is evidence of affiliation. 2,
that isn't what he said.
He said, "If you want get back, I'm from the Point." That's what he said.
And isn't there some evidence that he lived
So I addressed this in detail at the very beginning of my reply brief. Nobody who really knows Columbia Point in 2010 could possibly misunderstand that statement as, "Come find me at the Columbia Point housing project." That didn't exist in 2010. If you're in that neighborhood, in that place, you understand that, but more important, you understand Columbia Point is now the University of Massachusetts Boston in 2010. It's the Kennedy Library. It's not Columbia Point housing project. That was long since gone. So first of all, anybody who's from the neighborhood understands he's not saying, "Come find me at Columbia Point." He's saying, "I'm from the Point." The police, this is most important, the police, and they admit this, understood that when you say, in the context of a drug robbery, "I'm from the Point," what you're saying is, "I'm from the Columbia Point Dogs." That's what and there's no dispute about this. The police understood this was a possibility and they investigated it. That's the important point. Now, your second question is, yeah, but they went to the guy who's an expert in Rising Tide, this federal investigation, and those guys said, "No, we don't have any evidence that he's in Columbia Point Dogs." Isn't that the end of the matter? The answer is no. And this is the point this is where I said, my response was absence of evidence is not evidence of absence. But more to the point, what I'm really saying is that the fact that the police couldn't find additional corroboration of Dwayne Flannery's statement, of Kamani Washington's statement, does not prove that therefore he definitely was not a member of this criminal enterprise. People do not officially they don't give out cards, membership cards to criminal organizations. The point here is this is the suppression of exculpatory evidence. The prosecution, the government clearly believed it was possible that Kamani was a member of the Columbia Point Dogs for a lot of reasons, which I've summarized. They should have at that point handed that information over to the defense to let the defense determine for itself if they could find evidence of Kamani's affiliation with the Columbia Point Dogs, because this is exculpatory evidence. But they decided themselves, nope, good enough. We can't find any evidence of Columbia Point Dog affiliation, so there must not be any. So here's the final statement. I know my time is up. If I could just summarize. We have a combination here. We have powerful evidence that Dwayne Moore is not present for this crime. See Simba Martin's cell phone records. Combine that with the suppression of exculpatory evidence that Kamani was affiliated with and committing this crime on behalf of the Columbia Point Dogs. We submit that if the jury had all of this evidence together, that would have created a reasonable possibility that the jury would have concluded that come to a different outcome, that Kamani Washington was highly motivated to blame this crime on somebody else who was not Columbia Point Dogs, who was not present. And for that reason, we submit this case must be reversed. Thank you.
Thank you. Attorney Campbell.
Thank you. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. Before I start, I'd like to acknowledge the trial prosecutor, Edmund Zabin, who's watching via the live stream, as well as the victims' families who are also watching. We ask you today to affirm the defendant's convictions for the brutal and senseless murders of Simba Martin, Lavon Washam Garrett, Ayanna Flourney, and Amani Hotep Smith. I want to start with my brother spoke almost exclusively about issues that he raised in his motion for new trial. But I think it's important to view that in the correct context, which is the question that this court is tasked with answering is whether Judge Locke, who was the trial judge, abused his discretion in denying the defendant's motion for new trial. The defendant makes many assertions in both his brief here and in his brief and here today, an argument as to what the truth was. And quite honestly, it was for the jury to determine what the truth was based on all of the evidence that was presented before them. But even more than that, there was a 6-day evidentiary hearing on the claims raised by the defendant in his motion for new trial. And it was for Judge Locke to credit the witnesses and the evidence that was before him and make factual findings which should be upheld unless they're clearly erroneous. And when engaging in that analysis, the court asked whether there is record support for the findings that Judge Locke made, and there was. I'll take it out of order and start with the gang evidence. I think it's crucial. Judge Locke finds that there's absolutely no evidence that the defendant presented that Kamani Washington was in fact a member of CPD. That finding is supported. He talks about the 18-month federal investigation in which there is no evidence that Kamani Washington was a member of CPD. He talks about gang experts who say in their knowledge there is no evidence that Kamani Washington is a member of CPD. Though he says I'm from the point, I disagree with my brother as to what that means. I also disagree with his citation to the Lopes case. Lopes was a case in which someone in the aftermath of a shooting did yell out a gang affiliation, but there was much more evidence in that case as to that defendant's gang affiliation. There were gang experts who testified that that individual was a member of a specific gang and that the shooting happened in a rival gang territory. It was qualitatively a different type of case, and it wasn't that individual's gang affiliation did not rest upon a simple statement that they made in the aftermath of a crime. I'd also disagree with my brother's assertion that the point indisputably meant that someone was a member of CPD. If you look throughout the trial transcript, and you'll see that they talk about Marcus Hurd and that there was a Hurd family that was from the point. There's never any suggestion that Marcus Hurd himself or the Hurd family was a member of CPD either. It was just simply how they referred to people who had lived in that neighborhood in the past. So I would say that Judge Locke's findings on this point are absolutely supported by the record and should be upheld. He did not abuse his discretion in finding that there was no evidence that Kamani Washington was a member of CPD. Turning to the cell phone evidence, at base, my brother is arguing that Simba Martin's cell phone records definitively prove that the defendant wasn't there that night. They don't. Again, Judge Locke had the benefit of sitting through the trial and had the benefit of this evidentiary hearing, had the benefit of Christopher Ritchell, who is a senior radio engineer from AT&T, who described what these cell phone records show and what they don't show. It doesn't show anything about Dwayne Moore and his presence or his not presence on the street at the time of the shooting. I disagree with my brother's assertion here today that the Commonwealth agreed with him as to the sequence of events. If you look at specifically transcript 29, pages 13 through 15, and that's Marcus Hurd's testimony, he says that he calls Simba Martin to try to set up the drug deal. He turns onto the street, he parks a few houses, and then Simba Martin comes out of the house. So it's not his testimony that he calls and Simba Martin is just standing there waiting on the street and immediately goes over to his car. That's simply not the testimony. I think, as shown through the Commonwealth's briefing, but I think that the Commonwealth never disputed, and if you look at the way that this case was submitted to the jury, it was clear that this was a messy timeline from witnesses who gave imprecise evidence, which makes sense. If you think of Marcus Hurd and what he went through, it's not simply that he's recounting what happens. He was shot, he was paralyzed. A lot happened between the time that this event happened and the time that he was testifying. So that he gives some different statements, and he does give different time frames at different times to the police, and as opposed to what his testimony was at trial. I don't think that definitively sort of the sequence of events as presented by my brother is necessarily the only sequence of events. And certainly that these witnesses that were imprecise, that there were factual differences, that Kamani Washington was unreliable, that he had a motive to lie, that he had ingested both marijuana and liquor that night was certainly before the jury to take into consideration when they were deciding whether to credit or discredit this evidence. So that for that reason, I don't think that there's any basis to find that Judge Locke abused his discretion in determining that Simba Martin's cell phone records would have had any difference at all in this crime, where they don't show at a base level what the defendant is saying that they do show. I think it's important here too, because this is not a case, the defendant posits that the sole pillar of the Commonwealth's case was Kamani Washington, and I'm not going to dispute that Kamani Washington was an important witness. He was, but I think that key aspects of his testimony are absolutely corroborated by other evidence and by other independent evidence. So I'll walk you through that. I mean, you have the defendant's cell phone records, which established that he had a relationship with Martin. They established that he was calling Martin with frequency the night of the murder. He calls him 3 times before the murder. His phone is utilizing cell towers that are close to 23 Sutton Street, including 20 minutes before the murder. The defendant claims that doesn't show that he was at the scene of the murder, but I think it's important that in his second interview with the police, he puts himself at the scene of the murder. He puts himself on Sutton Street while he's speaking with Simba Martin. The defendant was the only person who had the motive to commit these crimes. He admitted that he had previously lived at 23 Sutton Street, but that he had been forced out at gunpoint a month before the murder. There was absolutely no evidence that Kamani Washington or any other person had the motive to commit this murder. The defendant also exhibited consciousness of guilt by at first having this extreme physical reaction to the police request to speak to him. When they just asked if they speak to him, when they take him out of the Pine Street Inn where he was working, he asked the officer if he's going to shoot him. He then, in his first interview, lies to the police and says that he never left his apartment at all that night, which they find to not be true. And he minimizes his relationship and communications with Kamani Washington. The defendant, through these interviews, though, also corroborates key parts of Kamani Washington's testimony. He told the police that the two had met and exchanged phone numbers first at Kearney Hospital and then near Blue Hill Avenue. They show that there were communications that night, both before the murder and 2 times after the murder, 1:32 and 1:50. The 1:32 a.m. call between the two corroborated Kamani's testimony that the two were not together at that time. They're using cell towers in different parts of Dorchester. The 1:50 a.m. call supports that the defendant was moving towards Kamani's home, as it is a distance away from the cell tower he had been using towards the location of 45 Fowler Street where Kamani was. The defendant also texted Kamani that night at 2:32 a.m. telling him to put the blame on someone else, which is indicative of their participation in the crime. The phone records also corroborated that Kamani saw the defendant the next day, and there are a number of text exchange messages between the two that are showing a planned meetup. And it's during this meetup that Kamani testified that the defendant told him that he shot the individuals in this case. You also have Marcus Hurd's physical description of the other individual. While the defendant tries to downplay it, it is consistent with what the defendant looks like. Hurd corroborated Kamani's testimony that he gave a speech about being from the point, that he left 23 first, and that by the time the victims were marched out at gunpoint, Kamani was gone. James Jones, who is a recipient witness, also, I think I agree, a rare occasion where I agree with my brother, but I think his testimony is critical. Now, my brother points to Fitzgerald Allen and shows that Fitzgerald Allen must be telling the truth. That was for the jury to decide. Both of those witnesses testified before the jury. They were able to look and see what James Joyce's viewpoint was as James Jones's viewpoint was as compared to the other viewpoint, and it was for the jury to determine who to credit. But James Jones's description is striking in that it's the way that he describes the defendant. He describes the same height, he describes the same build, but he also describes a head shape, that his head was small and that he had a low or bald haircut because he could see the street light shining off his head. That completely matches the defendant's description. It also matches Kamani Washington's mother, who gives a very similar description of the defendant, gives the same type of haircut, and gives a same specific type of description as to the shape and size of his head. So I think when you look at all of that evidence together, it provides a constellation of facts that determine and that shows beyond a reasonable doubt that the defendant was the individual who, with Kamani Washington, committed this robbery and who was responsible for the deaths of the 4 victims in this case.
Attorney Campbell, if I could, because I don't want to not get to this point. Obviously, when you look at the transcript of this trial, I mean, you've got 2 very experienced heavyweight attorneys here with Mr. Amabile and Mr. Zabin. Did Attorney Zabin cross the line? And I know what you might think, that you default wise, you've got to say no, right?
Correct.
But we've said over and over that some of the things that were in some of the tactics employed here about putting the jury, asking them to put themselves in the victim's shoes, this was a horrible, horrible, horrible crime. And what else would elicit sympathy but asking them to do something like this? That's one. The other is the reference to Attorney Amabile, which is bothersome. I understand that what he's alluding to may necessarily be what the jury's going to be charged with, right? They're the sole judges of the facts of the case. We get that. But to continue to refer to Attorney Amabile as the person representing this murderer, why is that okay?
So I'll take the last point first and then go to the first question. So I think it's important to look at it in context. It's ADA Zabin said it 2 times, and both times it was in the same context. So in the first, and this can be found, the area where he says it is volume 30, pages 105 to 106. He tells the jury, I don't need to tell you what the evidence is. His Honor doesn't need to tell you what the evidence is. And the man who is representing the man charged with murder in this case doesn't have to tell you what the evidence is. You know what the evidence is in this case. And the evidence, ladies and gentlemen, show that these murders, this incident was the very definition of brutal, unmitigated, premeditated first-degree murder committed with extreme atrocity and cruelty. So it's in reference to the roles that each individual was playing.
Yeah. Yeah, I get
And-
that.
and-
I get
and-
that.
And I think
Stood up
if you,
But if he stood up there and says, and you don't have to, you don't need this scumbag to tell you what the facts are, would that be okay?
scumbag, I believe, is more loaded. The man who's representing the man charged with murder is a factual description of what he's there to do. The second time, which is volume 30, pages 110 to 111, it's almost exactly the same, the way that he uses it. He says, it's not for Miss Anderson or even respectfully His Honor, and it's not for the attorney representing the man charged with murder. That decision belongs to you and you alone, and is a decision that you must make with great caution and care. That is the law and what you should do anyway. The defendant did object to this, so my answer is no, I don't believe so, because I believe it's a factual description of, and the way that it was argued in context is a factual description of what each person was there to do. But even setting that aside, there was an objection to it. There was a curative instruction given. After the curative instruction is given, Judge Locke invites them up to sidebar and he says, okay, do you want me to say anything else? And defense counsel says, and this is on volume 31, page 42, I think that was good. So he never suggests.
Wasn't there a conversation the next day? Wasn't this revisited by Attorney Amabli?
He wanted a mistrial, but at the point that Judge Locke is saying, okay, tell me what else you need to hear, he doesn't say, you didn't say X, you didn't say Y. He renews his motion for a mistrial, but I think I think the curative that was given cured any potential prejudice. Not that I believe there was prejudice, because I believe it's a potential proper argument. But when given the chance right then to tell Judge Locke, okay, and I need you to do X, Y, and Z, he doesn't. And I think that that's telling too. As to the sympathy part of the argument, I think it's qualitatively different than cases in which it's found to be over the line. I think it's a case that was tried on an extreme atrocity and cruelty basis. Do I think it is right up at the line? Yes, but if you look at the context of when they're talking about it, he's talking about the fact that they went on the view, that they stood in these places, that these places now have more meaning to the jury because they now know the evidence of the case.
But there was a little bit more discreet that bothers me about this, and it was the idea that there was a chronology to this, and the sympathy part of it. In if you're going to just silo it, maybe I hear you, but if you're telling the jury to watch through the eyes of that mother as she saw 1, 2, 3, when there was no testimony of the order of the murders, that it went from Heard to all of these other people, while this mother is laying there watching, waiting for her and her son's next turn in line. That's a big deal, is it not?
So my response to that is, as to the first, I think it's a fair inference as to the chronology. If you look at Marcus Heard's testimony, that they're lined up, he's the first one out. He's shot first, he's then face down and he hears gunshots. I think if you look at the placement of the bodies, it supports the chronology as well. So I think it's a fair inference based on both Heard's testimony and where the bodies are actually found, that supports the chronology that's given. As to the argument about Ayanna Florney, I don't think, if you look at it in context, that it did go over the line. If it did, that is just one portion. Where the chronology, I believe, was a fair inference based on the facts that were elicited in Heard's testimony. Where it was not objected to, and where the jury absolutely was told that sympathy was to play no part in their deliberations, I don't think it's a problem. I think too, if you look at the verdict that was returned, they weren't overly prejudiced and swayed by this because the defendant wasn't found guilty of extreme atrocity and cruelty. So for all those reasons, I don't think that this argument, even if it was improper, a point I'm not conceding, would require reversal in this case.
Thank you.
I'm happy to answer any questions that the panel may have. Otherwise, the Commonwealth will rest on its brief and ask that you affirm the convictions of this case.